Hi students, welcome to part 2 of our series on analogical reasoning. I'm going to share the screen. All right, this is where we left off from our last discussion. Um, let's start talking about how statutes and precedent work together. Statutes are a very common starting point. Statutes are binding on courts. Some rules start as common law rules and are later codified. So there's a lot of important relationships between the statutes and common law. More than a few times, courts may find that there's a statute that's unconstitutional, or a court may have to interpret the meaning of a statute. If the legislature disagrees, then it can always amend the statute. So the relationship between statutes and precedent remains rather fluid. When we talk about case comparisons, sometimes you need to look at cases in the past, previous cases, to compare and distinguish the client's case. And that, as we said before, is what analogical reasoning is all about. If you're arguing for a similar outcome, so let's say early in your paper you said, here is what the conclusion will be. And you find a case that supports that, and therefore you're arguing for a similar outcome, then you're going to be analogizing that case. If, however, you say this is what the conclusion will be, and you found a case that said the exact opposite, and you ultimately want to argue for a different result or outcome, you're going to be distinguishing the case. Now, in terms of reasoning, there are two forms. There's rule-based reasoning and analogical reasoning, where you're comparing and contrasting cases. You may do some rule-based reasoning in, your summer internships and whatnot, and certainly sometimes you'll have in some of your final exams. For our purposes, you'll be doing more analogical reasoning, so it's a really important concept that you understand. But first, let's talk about rule-based reasoning. Basically, it's very clear-cut. You just take the rule of law and apply it to justify the result. So for example, X is the answer because the principle of law in the case mandates it. You're done. I'm a bad may be found guilty of burglary because she entered the building with the intent to commit unlawful mischief under Vermont's burglary statute. Whatever happened in precedent doesn't matter. You're just really taking the law and saying, okay, our client fits within the definition of the law. Let me give you a hypothetical and give you a moment to consider it. Let's say there's a housing discrimination statute that reads, it shall be unlawful to refuse to sell or rent after the making of a bona fide offer, or to refuse to negotiate for the sale or rental of, or otherwise make unavailable or deny a dwelling to any person because of race, color, religion, sex, familial status, or national origin. You have a client with a rent house and she wants to refuse to rent to unmarried couples. Can she? Take a moment, look at the wording of the statute and apply it. Well, clearly she cannot, right? Because that's trying to discriminate based on familial status. So in terms of rule-based reasoning, the focus is on the holding from a case or the rule from a statute. Analogical reasoning looks at other parts of a case. That may include the facts or the court's reasoning for comparison purposes. You also apply the holding as well, but you've got to look at the facts. Keep in mind, an important goal of the final memo is all going to be about your ability to perform analogical reasoning in a competent fashion. When you think about precedent or cases, case law is helpful to provide definitions or interpret a rule, helpful to further define public policy arguments, explain the rationale. Cases are also helpful because there may be cases with analogous facts. When you think about legal analysis, I don't want you to think about the bottom line answer or the result. I want you instead to think about the why. In legal writing, your analysis cannot be done in your head. Think back to grade school and your math teacher saying, show your work. The same is true for legal analysis. You need to take your legal reader through your analytical process. You need to show your work. When you don't show your work and you just say, ta-da, here's my conclusion, then you're probably engaging in superficial or conclusory analysis. So always show your reasoning, and you want to avoid being called superficial or conclusory in your analysis, which is a big problem for many first-year law students. Lawyers are skeptical. Skeptical. Did I say skeptical? My goodness, I must be sleepy. Lawyers are skeptical. It's not enough for you to say, well, the law applies. You need to give them more information about that. If the law applies, why and how it applies. So case comparisons are based on the premise of stare decisis. Like cases should be decided in like manner. When you make predictions, you're having to draw analogies from similar cases. There will be similar issues, possibly similar fact patterns, maybe not. Or there may be some reasoning articulated by the court that applies, even though the fact pattern is really different, or really helpful policy statements. The final parts of this slide are from a slide from Sarah Ricks from Rutgers, and she talks about lawyers are really more like salespeople in the sense that what we're selling are analogies. The goal is to persuade the reader that the court is going to view facts as more similar to certain decided cases that you may find helpful. You want to, in order to do this effectively, assure the reader that the decided case is binding legal authority. If we're talking about persuasive precedent, well, the court doesn't have to follow it, but they do have to follow binding or mandatory precedent. You also need to assure the fact that what you're analogizing is essential. Remember earlier we talked about the different types of facts, and the most important facts are essential or outcome determinative facts. If it's not a determinative facts, it doesn't impact the outcome of your case. So let's say there is a lawsuit and it involves a woman, and the precedent case that you found also involves a female plaintiff, and you decided to put that in your analysis as a comparison point. Well, I'm going to say to you, well, so what? Is that an essential fact? If it's not an essential fact, it does not belong in your analysis. You also want to make sure you give the reader enough information to make their own independent evaluation on whether the fact from what was decided is truly similar, because lawyers are naturally skeptical. When you are arguing a case to a jury, juries don't really like to be told, well, this is it. They actually like for you to give them enough information so they can also have that aha moment where they're convinced that this should be the right result. So make sure you provide enough independent evidence so your reader, your jury, whoever you're trying to convince can have that aha moment where they're really following you, as opposed to you just stating a conclusion. Think about what analogy you're selling. Analogies must be explicit and obvious. So it's not enough to say, well, this case is similar to the Jones case. What aspect of this case is similar to the Jones case? That's what you're trying to argue. Look at these different examples. The first one says, here the trailer was separate from Miss Peloso's main house. That's kind of vague. Or like Piccaroni, here the trailer was separate from Miss Peluso's main house. Or like the unattached garage in Piccaroni, which was separated from the house by a cement walkway, here the trailer was separate from Miss Peluso's main house. That is an explicit, obvious analogy. And we already know they're going to put that together to try to advance their argument. Okay. But too often students will just say, well, this case is similar to that one. Okay, I'm done. Not enough. You actually have to spell it out, even if you think it's obvious. Busy readers like analogies that focus on binding legal authority, that the facts being compared are legally significant or essential. Distinctions are very similar. You just want to assure the reader that whatever fact that you're trying to distinguish is a determinative fact. You still want to give them enough independent information or enough information to make their own independent evaluation. And your distinction must be explicit and obvious. Now, it's not a lot of fun, but it is possible to build an entire legal argument just based on distinguishing cases. So when you're engaged in analogical reasoning or case comparisons, never just say this case is like or unlike precedent. Make sure you focus on explaining how a case is alike or different. Make sure your comparison or contrast is relevant to the specific issue you're addressing. Don't get so desperate to make comparisons that you get off topic. Stay focused on what issue am I supposed to be addressing right now. Consider making a list. Client facts and the precedent case. Are there any factors the court has considered in the past? List any client facts that relate to that specific factor. That will help you organize your analysis. So that is the end of our lecture on analysis. We're going to do some more in class, and the best way is going to be through some small group exercises. But first, I want to make sure that we had a good foundation before we get started. I hope this video was helpful to you. If you have any questions, please make sure to let me know. Thank you.